Good morning. Another warm day in February, imagine that. Who would have thought, right? Welcome to the First District Court of Appeals. Today is Tuesday, February 8th. We have 5 cases on the docket this morning. 2 are set for argument. The first case that we have is State of Ohio versus Egavy, and that's case number C220267, and that has submitted on the briefs. The next case is State of Ohio versus Walker, C220271, that has also submitted on the briefs. Then we have State of Ohio versus Gasper, C220218, that is set for argument this morning. If attorneys can identify themselves and their readiness to proceed.
David Hoffman for the appellant, Your Honor, ready to proceed.
Good morning.
Phil Cummings, Flint State, ready to proceed.
Thank you. Good morning. Then we have Lip versus the University of Cincinnati, C220312. That is also set for argument this morning. If attorneys can please identify themselves and their readiness to proceed.
Good morning, Your Honor. Ali Razagi on behalf of the appellees, and you are ready to proceed.
Can you be so kind as to repeat your last name a little slower so that I would be able to say it correctly?
Certainly, Razagi.
Razagi.
Yes.
Okay, thank you so much.
Sure.
Your Honor, I'm Tom Connors. I represent the appellants. I am ready to proceed.
Thank you. And the last case we have is Frank versus University of Cincinnati Medical Center, case number C220242, and that has submitted on the briefs. Okay, so State of Ohio versus Gasper, Attorney Hoffman, whenever you're ready.
May it please the court, Mr. Cummins?
Would you like to reserve time?
Yes, thank you, Your Honor. 5 minutes for rebuttal,
All right.
please. Mr. Gasper is appealing from a conviction for rape involving a claim that the victim was unable to consent to that rape. And the state produced evidence attempting to prove that the victim could not consent. And what I want to do this morning is run down the different claims and indicate why the evidence was inadequate for each of those points. The first, the main point that the state used to try to prove that the victim could not consent was the fact that she had, KW had an IQ that was below average. And on this point, Dr. Dreyer testified that IQ cannot be tied to an ability to consent, that individuals, even with an intellectual disability, can consent to have sex.
So ultimately, there were differing opinions from the experts, is that correct?
Well, yes, but the Dr. Dreyer had a lot more ammunition, Your Honor. She was able to cite reports, studies, almost a consensus in the psychological community that people with intellectual disabilities, even those with an IQ under 70, are sexual people and can consent to have sex.
But there was more to it than just the IQ test. I mean, Dr. Ness said he evaluated her, he met with her. It wasn't just that. There was more to it than that.
Yes, but what I wanted to do this morning is kind of break it down and handle them one at a time. But you're right. He said that KW in particular had a vulnerability to threats, that she would, because of her below average IQ, would take threats more literally or more seriously than other people. Now, this position of his was, Dr. Dreyer disagreed with that. And it turned out there were no threats, but Dr. Nestiti did say that she was more vulnerable to threats. I mean, she testified under oath there were no threats. And also, even during the investigation stage, I'm getting a little off track, but
Well, it wasn't charged under threats. I don't think that's an
I'm
issue
sorry?
here. It wasn't charged under that section of the statute.
That's right.
So I want to make sure we're on the same page. There were 7 counts, right?
Right.
6 of them, there was a not guilty verdict from jury.
Correct.
So we only have one at issue here, which is the one that you really are here on appeal with regard to.
That's correct.
And your first assignment of error is the Daubert challenge. You're addressing that. Why don't you talk a little bit about that particular assignment of error? Because you're talking about the experts, and that's really all centered on the Daubert challenge.
Okay. What I'd like to discuss about that assignment of error has to do with the knowledge element. Each expert followed a three-point analysis of rationality, knowledge, and voluntariness with regard to the ability to consent.
Here's my question that I'd love for you to answer. Unless I misunderstood the record, it's my understanding that the surviving count was not based on her disability, but on her capacity due to her medication.
That depends on who you talk to.
Okay.
I would take that position because I think it's logical to assume that, but the state had pointed out in their brief that you really can't read into verdicts. And
But
so,
how was it charged to begin with? Was it charged because of her mental capacity? Was it charged because of the,
well, the indictment listed everything. It just tracked the statute.
Right.
It said mental condition, it said physical condition or age, and which is what the statute says. There was a motion for a more specific bill of particulars filed, and instead of filing a written one, the prosecutor said, we're going to go for the mental condition. And I don't have the quote right in front of me because I wasn't prepared exactly to address this, but the way the prosecutor expressed it was that it was a condition that is all the time. The condition that she is under, sort of. I can't remember the quote, I'm paraphrasing.
because the bill of particulars was amended, was it not?
There was a motion for a more specific one, but I didn't see an amended bill of particulars. It was stated in court twice, and the defense attorney tried to get the prosecutor to nail down exactly what they were after. And the defense believed that it was IQ. It was not intoxication or something that would reduce a person's ability that would, reduce their ability to consent, but it was all or nothing. And that's the way the trial went. Each expert talked in terms of inability, either the person's able to consent or not able to consent. There was no language about a reduction of the ability to consent. And I don't know why they did it that way, but that's the way they did it. And there was a focus on the IQ. And another thing, Dr. Nestiti said that he noted the baclofen evidence in his report, so he knew about it, but he didn't rely on it for his analysis.
Counsel, was there any evidence that Mr. Gasper was aware that KW was taking baclofen?
I can't remember, honestly, from the record that I know that during the controlled call, it was suggested, KW suggested to him that she asked him if he remembered the first event when she was so tired, and he couldn't remember that. He didn't remember it that way, or didn't remember when she used her tiredness as a way to try to get him to remember. It didn't work. But that's the only instance when I remember when it was brought up, or there was an attempt to prove that he was aware of her being drowsy. He also said that she wasn't asleep prior to the first event, and she claimed that she was. That's all I can recollect right now.
Counsel, on that subject, though, two things. First of all, excuse my voice.
That's okay.
If I remember correctly, KW's mother testified that he was aware that she took that medication every night and that it made her sleepy. Is that correct?
That very well could be. I don't remember. I remember she was called by the defense, and I thought that the reason why the defense called her was because it seemed to me that they wanted the jury to see how much she would exaggerate. That's the way I took it. But,
and then, secondly, there's no way to know if the jury relied on the baclofen, right? I mean, there are no jury interrogatories.
that's correct. There is no way to know. and you can't read into it. But the evidence at the trial was such that, I mean, Dr. Dreyer really did nail down the fact that KW had the ability to consent. As far as this black and white, could she consent, could she not consent? I think she won that battle hands down.
Well, I mean, we don't know that because the jury found him guilty on one of the counts.
Well,
So
Sorry.
we don't know whether that's because of the baclofen or if it's because, the evidence of the first count was clearer than the rest of them. We don't know why the jury only found him guilty on one count.
That's right. You can't tell from the verdicts what they were thinking. You really can't. You're
So
not
you don't
supposed to
know
try.
if Dr. Dreyer won the battle of the experts. There's no way to know that.
I'm sorry, I didn't get the last part.
Sorry.
It's okay.
I'm not surprised you didn't get that. There's no way to know which doctor won the battle of the experts, correct?
In the jury's mind, correct.
Yes. And that's all that's important. It is, I mean, since we can't know what the jury was thinking, can we say who won the battle of the experts?
I still think I think a reviewing court can look at the evidence. That's why I wanted to go down the list. Because if you look at the evidence, I mean, you can reject. A reviewing court can say, well, there's nothing here about any kind of reduction, because the whole fight was about an ability to consent versus an inability to consent, not about a reduction, diminution of a person's ability to control their actions or appraise the nature of their actions. They chose not to go that route, and yet the jury picked up on this in an isolation, maybe relied on the baclofen evidence, and so anyway.
Because the charge that the jury came back with a guilty verdict was the charge in which the baclofen was discussed. Is that correct?
Correct. That is correct.
And I don't believe it was discussed with regard to the other 6 counts.
That is correct.
Okay, now, of course, the expert testimony that you are discussing, possibly would apply to all 7, but the baclofen seemed to only apply if it was applicable to her ability to consent to the first count.
Correct.
Counsel, did the state's expert take into consideration the fact that DNA from other men was found on a sexual aid in KW's possession? Do you know?
I was able to process the second part of your question, but not the first. Who was?
The
Oh.
state's expert.
The state's expert.
Was that a fact that he considered in his analysis on the capacity question?
I know it was located. I'm not sure if it was, I don't think so, because that report wouldn't have come back. I think his interview might have occurred prior to that, but I'm not sure. I can't answer the question. I'm sorry.
Thank you.
I don't know I don't remember him mentioning it.
Attorney Hoffman, you have about a minute.
About a minute? Okay. Irrespective of the basis for the jury's decision in count 1, there was no evidence that the baclofen made KW unable to consent. She, in that same scenario, she testified that she turned her head away when Mr. Gasper attempted to kiss her. She physically removed his hand repeatedly from her pants, and she demonstrated, non-verbally anyway, by her actions, that she was still able to decide what to do. She ultimately decided to go forward, but the baclofen didn't stop her from being able to do that. And so because of that, I'd ask that this court would find that the evidence was insufficient or contrary, that the conviction's contrary to the weight of the evidence and allow a new trial. If there are no further questions. Thank you.
Good morning.
To this direct question, the state's theory from the beginning was that the victim was substantially, her ability to consent was substantially impaired because of a mental condition. And this was made clear from the beginning all the way through. On page 19, they had a hearing, and the prosecutor specifically said, Your Honor, we are going through on the theory that she was unable to consent because of the mental condition that she suffers from. That's on page 19. Nowhere in the state's case does the prosecutor or the state ever elicit this information about the baclofen. This was something that the young lady brings up, and this is not part of the state's case. It came out because the young lady brought it up. We never argued, the state never argued that her ability to consent was overborne because she took her medication. This took on a life of its own just because she brought this up a couple of times, and it was discussed towards the end of the trial as to whether or not this changes the whole nature of the charge and did this somehow amend the indictment. And this was...
You're talking about the last assignment of error right now. Are you addressing the last assignment of error?
Essentially, yes, because they were asking for a new trial based upon the fact that the jury asked a question about whether or not they could consider this medication, presumably for this charge. And after discussion, the trial judge came back and emphatically said, no. She didn't say no. She said, just rely upon the instructions you've been given. And it was the correct decision. I think the state never relied upon...
If I remember that part of the transcript, there was an objection, correct?
At what point?
I'm sorry. There was an objection to the trial judge saying, these are your instructions, use them.
Oh, yes.
Correct.
The defense definitely wanted her to come back and instruct the jury, no, you cannot consider the fact that she took her medications. And the trial court refused to do that because she thought that this issue wasn't the theory upon which the case was tried. It wasn't the subsection of rape under which the defendant was charged. And she thought it would be error and it would be invading the province of the jury if she were to comment or weigh in on this relevance of this medication, because it was never really part of the state's case as presented. The expert found this young lady...
I'm sorry. And I briefly skimmed the closing argument again last night. There's no mention in the state's closing argument about this medication, correct? Or at least
Only-
there's no argument about
Correct.
I think it was mentioned very briefly.
She just mentioned it in passing as she summarized what happened the night of
Right.
that first
But there
count.
was no argument based on
She
that.
never argued that the consent was overborne because she took her medication, and that's my point now. This was never part of the state's case. It was never charged that way. It was never argued that way. And I think the trial judge did the right thing by not weighing in on this because it would have muddied the waters. They had all the evidence that they needed. The evidence about the medication was in the record, and it was not objected to. It was part of the record for the jury to consider, just as anything is in a trial. If the evidence is admitted, the jury should be able to consider it. But this was not part of the state's theory.
And I think that's the point. I think the point is there was testimony, so that was for the jury to consider whether whether it was argued or not is inconsequential.
Well,
Argument is not evidence, so, that's the starting point.
I think the judge instructs the jury that what you have heard is the evidence, and that included everything, including the references to this drug. So in that sense, you consider everything, and it was part of the case in that sense. I think another reason that this became somewhat of an issue was the jury instruction. And I think if you look at the jury instruction about substantial impairment, it does have reference to it's a present reduction or a present diminution in your mental status. And I think that there was some argument or questioning there among all parties as to what does that mean in the context of this drug. And I think the prosecutor's point was, this wasn't our theory. We didn't elicit this information, but the defendant takes the victim as he finds her, and on that particular night, she had taken her medication. That is part of the facts of the case, but it's not the reason that we are arguing that she was unable to consent.
Counsel, same question I asked your opponent. Was there any evidence in the record that Mr. Gasper knew about KW's use of baclofen?
Yes, I think he basically lived with the family for a long time, or at least spent hours and hours over there, very intimately aware not only of her medication, but of the ones he'd administer to her siblings. So I think it's, if it's not directly addressed, it's certainly inferred that he would be well aware of that, yes. I also want to note, too, that if this is something the court is going to be weighing in on or looking at, there was evidence in the record that KW testified that she's been taking this medication for a long time. She's used to it. She takes it all the time. She did say it makes her sleepy, but she said, I woke up, when he sat on the couch, and she was in the moment as far as that goes. So I think, from her own words, you can understand or infer that this is not something that overbore her consent at the time. And that's why the state never really argued that. I mean, she was used to this drug. You build up a tolerance. It really wasn't part of the fabric of the case. And that's why the judge declined to weigh in specifically on that jury question. And I think the state thinks it was the right move.
So I understand the state's theory. The case that the state put on was that KW was unable to consent at any time, regardless of what medication she was on.
Exactly. Yes.
Thank you.
Exactly. That's my point. And I think a lot of the issues that were discussed about the experts relying on that test about general sexual knowledge, I think it's important to note that was just one of many tests she performed. He did not have any records of this woman. She wasn't in the system as far as what he could access. So he decided to use that test just as one of many tools to get a feeling for what she knew, what she could comprehend. And I think that my colleague is correct. I don't think there's any evidence that Gasper threatened this young woman. I think the discussion of threats is important and relevant only to the extent that it illustrates how she perceives the situation. Certain issues were discussed. She perceives that as a threat. There's no evidence that this man killed her dog, but yet she perceives that that's what happened. And this all goes back to the expert's opinion that she has a cognitive problem processing certain information. She takes things literally. She has a narrative in her head that doesn't line up with reality all the time. And this all dovetails into, the state's expert's finding that overall she has a significant intellectual disability. And that substantially impeded her ability to consent. And that was the state's theory the whole time.
Do you know whether the state's expert took into account the DNA findings on the sexual aid?
I don't believe that was discussed. I don't believe he did. I don't think that was part of his, I don't think he was even aware of that, actually. I think his whole report was based upon his review of the testing and his interview with her. So I don't believe that was even known to him.
Would it have made a difference had he known that KW was involved in sexual activity with other men?
I don't believe so. I think his opinion is she would have been unable to consent to sex with anybody, regardless of what the number might have been. I think that was his final conclusion, that just because of her condition, she was not going to be able to consent in any circumstance. Unless the court has any other specific question.
Was identity at issue in this case?
Was identity an issue? No.
With regard to the victim, when she was testifying on the baclofen, was there any objection by either side?
No. No, I mean, that's another one of the state's points in the brief, was the fact that this medication was referenced in the Marison interview. It was mentioned somewhere else. It was often in her interview, I think, and it was never objected to. There was no motion in limine to strike that. There was no objection to the discussion of it when it came out. This only was a very late in the trial discussion after the jury came back with that question. That's what prompted the controversy about this medication issue, because it was never really part of the state's presentation at all.
So, Counselor, if theoretically this court were to decide that that was the reason, the baclofen was the reason that the jury came back with a guilty finding on count one, how would that affect this case and the validity, and whether the guilty finding was sufficient, like, based on sufficient evidence?
Well, if this court were to find that that was the jury's reason for the guilt, then I think it would call into question, the whole basis upon which he was tried. Should he have been tried under the first section about being drugged or intoxicated or something like that? But I think to do that, this court would have to invade the province of the jury, and that's not something that our system is set up for. It's not something that should be done. It's easy to do that in a case like this and to infer that we think we know what the jury thought and what they did, but we really don't, and it's a very dangerous thing to do. And that's why the law is that that type of decision shouldn't be made. We shouldn't look behind and try to divine what they did or why.
So what should we do with the fact that, the theory again was inability to consent, period, and the jury only came back guilty on the first count?
Well, accept it for what it is. For whatever its reason was, the jury came to that conclusion. And I think we can't look behind that. That's what the case law tells us. We can't assume that we know why they did that. And I think you have to assume the regularity of the proceedings until something else is proven otherwise. And you can't prove something like this. It's pure speculation, and it's invading the province of the jury, and that's why the case law cautions against it. So in a case like this, you accept the jury's verdict for what it is, and verdicts are often inconsistent. You often have, some counts are guilty, some counts are not guilty. That happens all the time. But they stand up. The courts affirm those because that's the way our system operates. Unless this court has any further questions, I just rest on
I just have a follow-up question.
Yeah.
So, at the end of the day, the issue here is because of the question from the jury. That's what's giving rise to the last assignment of error.
Yes, that's what the last assignment of error is about, yes.
We know the record is what the record is. There's testimony with regards to the baclofen. No one objected to the testimony, right?
Right.
So what if the jury had never made that question, and yet we're still facing the same assignment of error?
You mean just sua sponte, you'd be concerned about that medication?
Right. Defense would say, hey, the jury discharged on 6, found guilty on the 1. That's the only one that baclofen was at issue. Baclofen was considered. The jury had improperly considered baclofen in their determination of guilt.
I guess the answer would be it wouldn't make a difference. Whether or not the jury asked about this or this court itself decided to think about that issue, I don't think it makes a difference. Because in either case, we just don't know. We will never know. It's just speculation to infer something, to look into what the jury was deliberating, and that's not something we do. And so either way, it's a valid academic exercise, I suppose, but you can't prove prejudice in a case like this on this type of a record, because you just don't know what informs a jury's verdict and why they are inconsistent. And it does happen all the time.
Thank you.
Sure. Thank you.
You have your 5 minutes.
Thank you.
You have
Your
your
Honor.
5 minutes.
Mr. Cummins pointed out that KW may have been laboring under what she felt were perceived threats as opposed to explicit ones. And I just wanted to note that part of this offense involves not only the inability to consent, but the offender's awareness of that inability. And if these threats were only perceived in her own mind, that would make it difficult for the offender it would make it more difficult for the state to prove that the offender knew about it. Just wanted to mention that. With respect to, in response to the arguments for the final assignment of error, I don't know what the trial court the trial court was in a difficult spot in response to the jury question, but I think at the end of
My
the,
question is, does it matter? Because if the record is what the record is, there was no objection from either side. The jury had all of this testimony to consider. So the only thing that we have here is that the jury makes a question. Had the jury not made a question, and you raised the same assignment of error,
I would argue that the question, the failure to object, the question kind of took the defense attorney off the hook for not objecting, because it reopened it, for one thing. And the second thing is that the record is pretty clear that defense counsel was misled. And for the first point for the condition for a new trial is that the court makes an order that causes either the parties are misled or they're prejudiced. And I think that you've got that order. I'm not saying the order's wrong. I don't know what the court should have done. But it was an order, and the record was clear that the counsel was misled. He thought Backlevin was out of the picture, and it made it in the picture, based upon the prosecutor's specification. Yes.
I'm confused. Who misled? Who did the misleading?
I think that, I don't know. It wasn't intentional on the part of the state. It was just part of the background. I mean, it was a fact that was out there. But the state did say that they were proceeding only on IQ, the mental status that the person suffers under, with an S, suffers under all the time. And
But how did the state mislead? I mean, the state didn't make that argument. The state didn't elicit testimony about
right.
Backlevin.
I'm not saying, I guess I'm not saying that they did actively mislead. I'm saying that defense was misled, I guess in the passive sense.
Generally, though, if somebody is misled, somebody else has to do the misleading. So I'm confused as to who would have done the misleading.
The state that I can't prove that the state purposely stuck that Backlevin evidence in there, hoping that as a backup in case their main case didn't work. I don't know, but it got in there, and the parties clearly, both parties maybe, didn't believe it was a thing,
Okay.
and the jury thought it was a thing,
Okay.
and so they were misled, and so because they were misled, and the judge gave an order that allowed it to go forward. A new trial they should get a new trial.
Let me back up. So the jury instructions, was there an objection from the defense about the jury instructions before the jury was discharged?
Nope. Nope.
So there was no objection there?
No.
And then when the judge basically said, after the question came back, the judge basically said, I've given you the instructions, use them, correct?
Correct.
But there was there was an objection to that, but there wasn't an objection to the instructions that she originally gave, that she told them, use these instructions. I understand that the defense wanted her to say, no, you can't use it, and objected to her saying, these are the instructions. Mm-hmm. Stick with them.
Right. She almost had to say that. But the fact that the jury had to ask for permission, they were asking for permission to look at that Backlevin evidence, to use it, to convict this guy, my client, sorry. The fact that they had to ask that question just proves that the whole case wasn't about it. Why would they ask the question, I mean, are we allowed to use this? They wouldn't have asked it if some theory was presented to them that backed it up. There was zero on it, and yet they apparently returned a verdict on it. So I think a new trial's in order. Ask that the court would reverse. Thank you.
Thank you. Thank you both for your arguments this morning. We'll take the matter under submission and issue a timely decision. Have a wonderful afternoon. Lip versus University of Cincinnati. Attorney Connors, you can come up to the podium. Good morning.
Good morning.
How are you?
I'm doing well.
Would you like to reserve time?
Yes, 5 unless it's shorter, unless I don't use the
And
entire
if it's
time.
shorter, I'll carry it over. How's that?
All right, great. Good morning. I represent
morning.
Benjamin Lip and 3 other University of Cincinnati students who sought declaratory relief regarding 4 COVID-19 regulations. The main issue is standing, which is defined under Ohio law as having a personal stake in the outcome of the claim as alleged. It does not involve a question of the merits. And that personal stake can arise when the plaintiffs are placed in the dilemma of either complying with a regulation and giving up their rights or facing sanctions. And that would be the Burger Brewing case. That would be the Ohioans case. That would be the People's Right case. That's clear law. The further issue in Burger Brewing was...
Are you saying that that would be the injury?
I would say the interference with their legally protected interests would be the injury, correct? Now, the question here is in dilemma, whether they're placed in a dilemma raises another question as to whether we may presume that the law will be enforced. And that has been settled by the Ohio Supreme Court in the Wilson case. The courts are to presume that laws will be enforced. So,
What effect does it have that these requirements have been revoked by the university?
that's an entirely different issue. That would be mootness. And the standard there, when there is a voluntary cessation of a challenged action, the party that voluntarily ceases has what is described as a formidable burden of showing that it is not reasonably likely to recur. And in this case, in fact, it did recur when the masking mandate was reestablished for medical students. And these are not medical students, but that's not relevant. What is relevant is that we have evidence that it is reasonably likely to recur. So
Where in the record would we find that? Is that attached to the amended complaint, or is it somewhere else?
Well, it wouldn't be attached to the complaint because mootness arises by definition as a result of actions that occur after the complaint. It would be evident from public documents which are on the internet. So I'm not saying that those
I'm not sure
documents.
we can take judicial notice of public documents on the
Right.
internet.
So we know that there was a cessation. What we don't know, and what is an issue of fact, is whether or not it's reasonably likely to recur. And the burden is on the party that's saying it ceased to establish that. And the Brown case cited to you in the briefs makes that point. So there can be, mootness is not an issue that may be resolved at the pleading stage. There needs to be a burden met, evidence presented, a hearing. This is not something that can be addressed by mootness. So if standing is established, mootness hasn't been established by the party, in this case, the state. So I think those issues are clear.
Counsel, can you address where in the amended complaint the facts appear to establish standing for each of the 4 policies that you're challenging?
Yes, I can. The first, the question is what facts need to be established? In People's Right, what did they challenge? A statute regarding assault weapons. And they said they had assault weapons. They alleged that in the complaint. That was sufficient to establish standing because they showed that they had a personal stake. In this case, what did they allege? That they are students at the University of Cincinnati, that there are 4 mandates that threaten to expel them if they don't comply. That is sufficient under People's Rights. which is what Ohioans for Concealed Weapons found just a year or two ago.
One of the policies that you challenged is the quarantine.
Can I pause you for a moment?
Sure.
Karen, can you please, I think that's probably construction. Can you ask them to cease the construction until we're done in court? I apologize.
No
I want to
problem.
make sure that you're heard.
I appreciate that. Thank you.
One of the policies that you challenged is the quarantining and isolation policy.
Yes.
Does that specific policy require expelling students if they don't comply?
All of the regulations are subject to discipline. The discipline includes gradated actions up to expulsion.
Can you point me to where in the record it says that? I reviewed the quarantine and isolation policy, and I don't see where there's any enforcement mechanism in it. Can you describe for me what happens if someone doesn't quarantine or isolate?
I can only cite you to again, it's a public record. It was referenced in the briefing. The only allegation in the complaint was that there was that mandate, that there was a requirement of isolation.
What do we do? I know you attached the specific policies as exhibits to the amended complaint. What do we do if the amended complaint describes the policies differently than the exhibits themselves?
Well, the exhibits are embraced in the complaint, so they are part of the complaint. I would not agree that they are describing it differently. If there is any inconsistency, it's still in the complaint.
All right, thank you.
Sure. If standing and mootness are resolved, the only issue remaining would be whether or not motion to dismiss for failure to state a claim was in fact an issue. I don't believe it was addressed by the trial court. You can read the order. It clearly wasn't. Therefore, those issues are not ripe for appellate review. Even if they were, the essential elements of a declaratory relief claim are alleging a justiciable controversy, which overlaps with the standing concept, which has been established. And even if you got to the merits, and I won't get to them, I will see if they're raised before I address that. But if there are no further questions, I will simply reserve the remainder of my time and respond to
All
what
right.
the university says.
And I've added a minute to your time.
Thank you.
Good morning, Your Honors. Ali Razagi on behalf of the Appellees, the University of Cincinnati, and the Board of Trustees. At the height of the COVID-19 pandemic, the University of Cincinnati did what any reasonable, responsible institution of higher learning would do. Using its broad authority to administer a university, UC implemented several minimally intrusive policies and procedures for those who are coming onto campus for the health, safety, and well-being of its students, faculty, and staff. Now, as the conditions of the pandemic improved, UC began curtailing some of these policies to conform with the updated CDC guidelines and national trends. And eventually, as Your Honors pointed out, those policies were rescinded altogether.
Counsel, I have a question about that.
Yes.
It appears from the record that 3 of the policies were rescinded based on the evidence that you submitted, but I couldn't find where the quarantine and isolation policy was rescinded. Does that appear in the record anywhere?
Yes, Your Honor. I believe the quarantine appeared as Exhibit E to the motion to dismiss. And what was the other one?
Just the quarantine.
Oh, the quarantine one, yes. That's That's where you'll find that.
And that would be the current status of the quarantine policy at UC?
That's
Exhibit
correct,
E?
Your Honor. It is rescinded, yes. And that brings us to the first point, which is that because these policies have been ultimately rescinded, some for over a year and others for a period of 8 months to a year, that is why the trial court correctly determined that those claims, the plaintiff's claims, are now moot. Now, the claims are moot because there is no reasonable expectation that UC will reimpose those policies at any point during the future.
Mr. Razagi?
Yes.
Your opposing counsel has pointed out that the med school did reinstate. Does that have any effect on whether the claims are moot?
Not at all, Your Honor. I don't think it takes a leaping assumption of logic to understand why masks would perhaps be required at the medical school. In fact, if you walk into any hospital nowadays, you'll still find that masking is required for everybody who is entering into the hospital. That policy, regardless of the status of it, does not at all apply to the university at large. The university has rescinded its policies, and there is no reasonable expectation that those policies will ever be reimposed in the future. My adversary brought up,
Were any of these students medical students?
not as alleged in the
Plaintiffs.
complaint, Your Honor, not to my knowledge either.
Counsel, to what extent do any of these policies track recommended guidelines from the CDC?
Your Honor, as far as my understanding is that all of the policies, whether they were implemented in the first place or as they started becoming amended and eventually rescinded, it was all in accordance and to conform with the CDC guidelines. And that's exactly what the University of Cincinnati was doing, was basically following the national trends and, more importantly, the CDC guidelines, both in implementation and eventually in rescission of the
And
policies.
so would a decision from a court then make the plaintiff's asserted injuries redressable in light of the fact that other government authorities are also recommending similar policies?
Can you repeat that, Your Honor? I'm not sure I understand.
Would a court decision redress the plaintiff's injury, given that other intervening government authorities are also imposing similar quarantine isolation periods, et cetera?
Would it redress it in terms of, does it give them standing?
Yes.
I don't believe there's any standing here based on what other courts have done. I think standing has to be determined based on what's pled and alleged in the complaint, and nowhere in the complaint is there any injury that is alleged. The plaintiffs have never alleged that. Well, first of all, let's start with the vaccine policy. Okay, so.
That was my first question.
Yes.
To opposing counsel was injury. And they basically, as I understood it, it was the policy itself and being subjected to it is the injury.
Your Honor, I don't believe I ever saw any sort of allegation in the complaint that the plaintiffs were subjected to any policies. The vaccine policy, I think, is the easiest one that we can get rid of right away. The vaccine policy, the 3 students, as alleged in the complaint, 3 of them received exemptions, 1 of them was fully vaccinated. So there's obviously no injury there. They're not subject to anything there. The other policies, the testing, the quarantining, and the masking policies, nowhere in the complaint did the plaintiffs allege that they were on-campus students. Nowhere in the complaint did the plaintiffs allege that they were required to undergo any of these safety measures, whether they were required to quarantine, whether they were required to mask, whether they were required to be subjected to testing. Nowhere in the complaint that they alleged that they suffered any injury or any adverse action as a result of the policies that were in effect and ultimately eventually rescinded by the university.
So any injury, as I am understanding your argument, any injury would be too speculative to establish standing.
That's exactly right, Your Honor. And in fact, the Ohio Supreme Court has held that even in asserting a claim under the Declaratory Judgment Act, there nevertheless must still be a showing of actual present harm or significant possibility of future harm. And that's not alleged anywhere here. The fact that there is no allegation whatsoever about being subjected to the testing or being on-campus students who would even be subject to the policies in the first place, much less any allegation that there was some injury as a result of noncompliance with these policies.
Counsel, your opponent has said that there should have been a full hearing as to mootness and that we should not consider just the complaint and your filings with regard to that particular issue. What is the universe of information that we can consider in weighing the mootness question?
Your Honor, that's an excellent question. I think everything that was attached to the motion to dismiss and the amended complaint are fair game, because the updated policies which the university attached to its motion to dismiss, they are part of the pleadings as far as the rules of procedure go. It would only be well, first of all, I would mention that the policies were initially referred to and attached to plaintiff's complaint or their amended complaint. But just as importantly, out of fairness, because they're central, those policies are central to plaintiff's claims, that the updated policies which were attached to the motion to dismiss are similarly and equally part of those claims. So in other words, only looking at one side of the ledger, only looking at the initial policies that were implemented, but not considering the amended policies that rescinded the policies, it would be tantamount to a plaintiff attaching a contract to a breach of contract action, but not attaching an amended contract, which would negate any sort of recovery that the claim might have. So out of fairness to both parties, if the initial policies which were referred to and are central to plaintiff's claims and were attached to the amended complaint are part of the proceedings, then it would be equally fair for the updated policies to be part of those proceedings as well. And then moving on to the failure to state a claim. Now, one issue as a threshold matter, the failure to state a claim was never addressed by the plaintiffs in any of their briefs. So as far as the UC is concerned, that argument has been abandoned. Now, counsel has said that nowhere in the decision does it refer that the claims were dismissed for failure to state a claim, but the decision clearly states that in addition to standing and mootness, and for reasons stated in defendant's motion to dismiss, that the motion is granted. Well, as the defendants argued in their motion to dismiss, it wasn't just the standing and the mootness, but also on the merits for the failure to state a claim. And so for that reason, we would ask, for the third reason, that the trial court correctly determined that the claims should be dismissed.
Doesn't the next paragraph, though, doesn't that undercut it? I mean, because the next paragraph says, accordingly, because none of the plaintiffs are being forced to receive a COVID-19 vaccine, they lack standing. Further, if they had standing, and then it says it's moot. It doesn't. So that second paragraph seems to undercut what you're saying and undercut the first, any argument that the trial court determined it on the 12b-6.
Your Honor, respectfully, I would interpret that as not necessarily undercutting it, but further elaborating without specifying the additional details. I mean, when I look at it in the context of the previous paragraph, which states that for the reasons expressed in the defendant's motion itself, that the plaintiff's claims are rendered moot, I think that the next paragraph is perhaps further clarifying or elaborating, but I don't believe that the fact that the merits, the failure to state a claim, is not explicitly referred to in that paragraph, I don't believe necessarily undercuts or minimizes the previous paragraph. At least that's how I would interpret it, Your Honor. So beginning with the first claim, which was the violation of plaintiff's alleged constitutional right to refuse medical treatment. This was based on the masking policy and the vaccine policy. Masking is not a medical treatment. Asking your students and your faculty and your staff to mask is not a medical treatment. The courts who have considered this issue have concluded that masks do not implicate the constitutional right to choose to refuse medical treatment. In addition to that, these policies, the masking policy and the vaccination policy, do not constitute forced medical treatment as a matter of law. Plaintiffs were not forced to vaccinate or to wear a mask. The vaccine and the mask policies were well within UC's authority to issue public health guidelines. There were several courts that have upheld the same restrictions under the same circumstances that had far more intrusive policies than the ones that we're talking about here. So for those reasons, the constitutional right to, the alleged constitutional violation for the right to refuse medical treatment fails. That argument fails. That claim fails. The next claim that the plaintiffs have asserted in their complaint was the discrimination claim pursuant to Section 3792.04. That's the section, first of all, in subsection B1, which prohibits a university from requiring the students to take non-approved, FDA-approved vaccines. That provision is moot because Pfizer and Moderna are approved vaccines. And we know that because the courts have unanimously held that they are. That Pfizer and Moderna are fully approved vaccines. So subsection B1 doesn't apply at all because the students were not being forced to take any sort of non-FDA approved vaccine. As for subsection B2, there is no allegation whatsoever that the plaintiffs here were subjected to, or that they were required to test, that they were required to quarantine, that they were required to wear a mask, nor did they specifically allege how they were discriminated against or subject to different policies and different testing procedures or different masking requirements than somebody who received a non-FDA approved vaccine. So for those reasons, that claim fails. Moving on to the third claim that the plaintiffs have asserted, which is that the university lacks authority pursuant to Section 3709.212. This one we can eliminate very quickly. That statute is not applicable at all because, simply put, University of Cincinnati is not a board of health of a city or a general health district. Ohio law, as I mentioned before, gives public universities broad authority to impose health and safety regulations for their campuses, and we see that in Section 3345.021 and 3361.01. Both of those statutes confer considerable broad authority for the university to administer the university, which also includes imposing health and safety regulations for the safety and well-being of their students, faculty, and staff. And then lastly, Your Honors, the coercion argument. That one is pursuant to 2905.12. That pertains to the vaccine and the masking policy. This one we can eliminate fairly quickly as well. That statute is not applicable because it's a criminal statute that doesn't create a private cause of action. And the courts that have analyzed that statute have consistently held that that statute does not create a private cause of action. And just as importantly, the appellants here were never forced to do anything under the language of the coercion statute. The plaintiffs here were never forced to do anything under those former policies. They were never forced to vaccinate. They were never forced to test. They were never forced to quarantine. They were never forced to mask. Those policies, albeit have been rescinded, those policies at the time they existed were merely a condition of being physically present on campus. So there was no coercion, even if that statute created a private cause of action, which it didn't. I will yield the balance of my time to the floor.
Thank you.
Thank you, Your Honor.
I think there's a misconception regarding the concept of injury in the context of this claim. Again, opposing counsel is saying no injury is alleged. The injury is the invasion of legally protected interests. That is black letter law. The dilemma that is what permits pre-enforcement relief. All of these arguments about no one has forced them to do this or that. There were regulations that said you will be expelled if you do this or that. And the students don't have to wait and challenge or submit themselves to the sanctions. The courts have repeatedly said this.
Which policies said that they would be expelled if they did not abide by the policy? Which of the specific policies contained being expelled as a remedy.
The vaccine and the testing specifically said that in the policy.
Thank you.
I can't remember which other one was referred to as being subject to disciplinary action. So at least 3 said that in the policy, but all of them are subject to discipline under the disciplinary code, which is, again, a public record that can be looked at and considered. I've never said that the public records couldn't be considered. That's not an issue that I'm making. My point is that a citizen of Ohio who is subject to a law that says you will be punished can go into the court and say, I believe my rights are being interfered with. It's not injury in the sense of somebody broke my arm or took my money, but that I have legally protected interests under the various constitutional provisions and statutory provisions. That's what an injury is. Pre-enforcement relief is clearly allowed. And when we get to mootness, if the university wanted to actually moot this case, they could come up and enter an agreement and say, we will not reinstitute. That would make it clear. But they have not. They've retained that authority, and even in those documents where they said we're rescinding, we will, keep observing, and we have the right to do this further, and in fact did it in the case of the medical students. And I'm not saying where they have to be a medical student. That's evidence that they are likely to recur this. So those are not real issues. The failure to Well, no, one other point here. Broad authority to administer. This is a gentleman on behalf of the Office of the Attorney General saying that, that these mandates are authorized by Ohio statutes that give general authority to administer to the university. The Ohio Attorney General went before a federal court arguing the exact opposite in Louisiana versus Becerra. Came out in November of 2022. They got an order declaring vaccine and masking mandates as unconstitutional. And that was involved the Head Start case. The Ohio Attorney General was one of many Ohio Attorney Generals who brought this claim to court, and I am very glad that he did, and argued that the Head Start argued, wait, we've got a broad authority to administer. And the court said, no, the broad authority to administer does not mean you can do anything. It means especially in areas of significant controversy, such as the vaccine and mask mandates, there has to be some clear indication that that was intended to be authority granted to you. Now, Your Honor, you mentioned recommended guidelines of the CDC. And wouldn't that affect redressability in the sense that the CDC is recommending? And I would say this, the CDC does not have authority to set public health law in the state of Ohio. That is the responsibility of the Ohio legislature, and they have done that. They have said that the authority regarding immunization and health measures of this nature belong with the Department of Public Health. So the argument that it simply comes down to this statute only applies to departments of health misses the larger picture. That is one aspect of authority that was granted to the Department of Health, to both at the state level and the local level. That authority was not granted to the public universities, and they cannot come up and say, well, the CDC recommended it, and we decided that regardless of the fact that we, as a state agency, are going to assume authority not granted to us by the legislature. And with regard to the Becerra case, the Ohio Attorney General is the highest legal officer of this state. They've got a duty to the law. When they go before the federal court and make this argument that simple authority to administer to the head state is not sufficient to include authority to issue a vaccine and mask mandate, they've got a responsibility to not come before another court and argue the exact opposite, and that's what's going on here. And I apologize if I'm a little excited about that, but I think that's a profound error, if you will.
Counsel, you have a minute left.
All right, thank you. Now, we've talked about the questions of medical treatment, fact issue. They're saying we should dismiss this now at the pleading stage because, well, we all know wearing masks is not medical. Now, allegations are in that complaint that the FDA authorized masking only as for emergency use, only because they are as medical devices for medical purposes. Let me argue the facts. Let me go into court and present evidence before we dismiss that claim. The coercion, saying it's a criminal statute. No, you can't do it. No, there's a statute that permits civil damages for criminal acts. And specifically, you can't go to the Court of Claims until you get a finding that there was a criminal act, and I'm allowed to come in and ask for declaratory relief. That's what I'm doing. These are fact issues. You don't dismiss at this stage without allowing a hearing, without allowing discovery. So I thank all of you for your time. It's quite an involved case. I think I've said enough. I appreciate it.
Thank you. Thank you both for your arguments and for your advocacy this morning. We will take the matter under submission and issue a timely decision. Karen, if you can pause, let me get my paperwork together, okay? If you can pause, because I see you about to go for that gavel. I'm just saying pause for a moment. Don't gavel me until I'm ready. Okay. All right. Thank you so much again, and have a wonderful afternoon. All right, Karen, I'm ready. Thank you.
Court of Appeals,